So divorcing couples often assume that trusts and inherited assets are safe from division, but are they really? Let's dive into a situation that happens more often than you might think. So a while back I had a client come to me, we'll call her Emily, and she had inherited $100,000 from her grandmother during her marriage. Now, she believed that the inheritance was completely untouchable during her divorce. After all, it came directly from her family, and she kept it in a separate account. But Emily didn't realize that how she used that money mattered just as much as where she kept it. She had taken $20,000 from her inheritance and used it for the down payment on the family home, a home that was titled in both her and her spouse's names. Now, by doing that, Emily inadvertently commingled her inheritance with marital property. So when the divorce proceedings began, her spouse argued that the $20,000 became part of the equity in the home, which was now subject to equitable division between the two of them. And believe it or not, the court in this case agreed. This happens because commingling can blur the lines between separate and marital property, making it fair game for division. Now, in this particular case, the court decided that there was enough evidence that the $20,000 was a gift to the marriage, making it marital property, which gave her spouse the right to make a claim for a portion of it. Now, trusts can be even more confusing. Imagine you're the beneficiary of a trust that was created to provide for your financial needs. If the trust allows you full control over the assets and you've used them to pay for marital expenses like a family vacation, a home renovation, or joint bills, your spouse could argue that those assets should be included in the marital estate. In some cases, but not all, this might hold up in court. However, if the trust has restrictive language, and this is a really important key thing to remember, perhaps it explicitly states that the funds are for your personal use only, or that they're protected from division in a divorce, then it might very well remain separate property. But even then, it's not always so cut and dry. So here's another twist. Let's say you never touch the inheritance or trust and it remains separate. Your spouse could still argue that any growth in value during the marriage, like interest, dividends, or property appreciation, should be shared with them. This often depends on the laws in your state and how the growth occurred. Now, here in Georgia, passive growth in the value of an investment from something like market changes remains separate property. However, if your spouse contributed significant time and expertise to managing the assets, or used marital funds to maintain them, such as an inheritance of rental homes that need maintenance and improvements over time that aren't paid for from the rent that the homes generate, but are paid for from income earned during the marriage, well then, yeah, there could be a claim that some of the growth in value of those homes would be marital property. I know this stuff is tricky, and if you're navigating a divorce and you're worried about how your trust or your inheritance might be affected, you don't have to go through it alone. Reach out if you're in this situation. We'll help you figure out what's at stake so you can protect what's yours.
Thank you very much.
Hey, thanks for watching. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. Please share these videos and leave us comments and ask us questions. Also, join our Facebook group at Georgia Divorce and Custody, and I'll see you again on the next video.